Hi, my name is Danielle Olofsson, and for those of you who don't know me, I am a member of the commercial team here in Montreal, and my area of expertise is data protection and cybersecurity. Thank you very much for joining me, and what I'd like to talk about today I'd like to talk about the privacy representations and covenants that we usually encounter in our documents. I have intended designed today's class to be very practical. So we will be looking at actual language that we find in the various agreements that we're called upon to draft or to comment. And the idea is really to understand why this language is there and what we really need to see in these documents when we're reviewing them. So I've decided to group the presentation into two areas. So the first would be privacy and the second will be anti-spam, because those are really the two areas in which I'm called to intervene, as well sometimes as technology and of course cybersecurity. What I'd intended to do today is to structure the program so that we would first of all look at the law and figure out what the legal requirements are in these two areas. And then in a second half, look at how we reflect these legal requirements in the documents that we're drafting. So let's start with data protection. Now, data protection has become an increasing concern and is much more on our respective radars in the last few years. I would say since 2018, but perhaps even before. Anti-spam, we'll see, has been around for a lot longer than that. But in 2018, the European Union really tightened its data protection legislation with the GDPR, so the General Data Protection Regulation. And it sent a message to the planet that if you wanted to exchange data with European entities, certain protections were going to have to be in place. The fallout of that is that now our agreements, be they mergers, asset, share purchase, our transactional documents have to reflect certain commitments to protect data if data is involved in the various transactions. Now, with respect to data protection, where this becomes important for us is in two areas, the representations and also in the covenants. But let's start by looking at the legal requirements. Legal requirements in the area of personal information protection really cover three areas. We have governance obligations or duties. We have operational now obligations and duties that are increasingly imposed upon entities by these various laws. And then there's this area of individual rights. And what I mean by that is that if we collect information on individuals, these individuals are allowed certain rights with respect to the information that is being collected. So to begin with the first category, which is governance, again, we have three sort of subsets that we're really looking at here. And the first I've called roles and responsibilities. Now, what this is that the laws require us to define what each, I wouldn't say person, but what each role or what each person, I guess each person does with respect to the personal information that they process or that they come across in the life cycle of this information. So from collection to use to disclosure or disposal of this information. In Quebec, for example, we've just enacted a law that is coming into effect over the next 4 years. And one of the first things this law is going to change is it forces us to designate a person who is ultimately responsible for the protection of personal information in a particular organization. If we do not do this, this role will de facto fall onto the person or body with the highest decision-making authority. And that usually is a CEO who, in my experience, really has a lot on their plate and would prefer not to have to be responsible necessarily for this. So it's always a good idea to remind clients that they need to have designated somebody who will be in charge ultimately for the protection of personal information. But we also want to know what HR does. For example, the head of HR, it's their obligation to make privacy policies like any employee policy available, explain them, answer questions. Sometimes they're in charge of granting access or even enforcing privacy policies. What is the role of technology, tech services, the chief information officer with respect to the protection of personal information? So this is all information that we need to formalize. And how do we formalize it? Well, we formalize it in policies. So what the laws require of us is to put in place policies and procedures for two reasons. First of all, for internal governance, to make sure that we are, in fact, able to honor our responsibilities, but also to be able to communicate what it is that we as an organization do with an individual's personal information. So the policies that we typically like to see when we're doing due diligence are obviously a privacy notice that you'll find on an organization or company's webpage. So it's their typical privacy notice. Sometimes it's called privacy policy. We also want to see an employee privacy policy or an employee personal information protection policy, which describes how the organization is processing its employees' personal information and what the rights of those employees are with respect to the information that's being collected. Very, very important is an incident response policy. And this has been required of any organization that is subject to the federal legislation as of 2018. It is now going to be mandatory in Quebec as of September, and it has been required in Alberta as of 2010, if I'm not mistaken. And each American state also has incident response and notification obligations. So that is an incredibly important policy to have, the incident response policy. Also, we want to have data classification policies and data retention. I've called it destruction on this, but I guess that's a violent term. What I really mean is retention. How long are we going to keep the information that we're collecting? Because we have an obligation to destroy information when it is no longer serving the purpose for which we collected it. Also, and increasingly important, is a procedure on data subject rights. How are we going to respond to an individual who asks to see their personal information or to asks to have their personal information corrected? We have obligations to respond to this and to respond to them within a certain amount of time. Best practice is a month, so 28 to 31 days. And then in this category of governance, we have documentation and requirements. So we have to really evidence that we are doing what we say we're doing. So for example, we need to keep consent registers. If individuals give us information, consent to give us information, then we need to keep registers that evidence this consent. And this is especially important, we'll see when we're talking about anti-spam legislation, our CASL legislation. Incident registers. So not only do we have to have an incident response policy, but we also have to have an incident register. And this register is very important, first of all, because the authorities can audit a company anytime or an organization anytime they want. But it's also important to keep a register because we may not have to disclose every data incident that occurs. There may be incidents that really don't have a risk of substantial harm, and therefore we don't have to disclose them. But what we do have to do is document them so that if we are audited and a commissioner, for example, asks us why we did not disclose or why we did not notify of this incident, we have to say, well, look, this was a thought process we went through when we knew we had this incident, and this is how we logged it. And so it's really just sort of backup and supporting documentation. We also have to have data subject request registers. So every time an individual makes a request concerning their personal information, we have to log that. So those are the governance requirements. Then we move to operational requirements. So these are increasingly, well, these are requirements that various laws impose upon us. So for instance, with respect to privacy impact assessments or analysis, every time an organization updates or introduces, or updates a system or introduces a new software, a new process whereby personal information will be affected, they need to run a privacy impact assessment or analysis. This sounds highly bureaucratic. It is not. It's just simply, I guess it's sober second thought. What we want is to see that an organization has thought about the, let's take software for an example, the software that they're introducing and the effect that the software will have on personal information protection. For example, in Quebec, one of the questions that we have to ask ourselves in a personal impact assessment or analysis is, will this software enable us to communicate the information that we collect in a machine readable fashion to the individual? Because there's an obligation, which we'll see in point 3, there's a data mobility obligation. So we have an obligation to communicate or to transfer data to an individual if they ask for their data. And so what we want to see in our PIA or privacy impact assessment is this ability to do that. Will the software enable us to do that? Operations, we also, as I've said, have consent requirements. In Canada, regardless of the jurisdiction, it is very much a consent-based regime, it being data protection. And what I mean here is that in order to collect, to use, to communicate an individual's personal information, unless there's an exception, we really need to have that individual's consent. And again, we have to be able to evidence that consent. Another thing that we are seeing increasingly, and that is absolutely best practices and that we should have and that we are obliged to have if we're exchanging data with other jurisdictions such as the European Union jurisdictions, is data processing agreements. So every time that data is communicated to another party, we want to make sure that there is an agreement in place that protects that data as well as we are protecting it. So what we want is we want to describe what data is being processed, what processing it is subjected to, will it be subjected to analytics, is it simply for payroll purposes, what are we actually doing with this data, and how are we proposing to protect it. So those are the elements that we need to see in data processing agreements. The third area that the laws, our legal requirements affect, are individual rights, or in Europe, data subject rights. In Canada, regardless of the jurisdiction, every individual has the right to ask whether an organization is in fact processing their personal information. They have the right to access that information and to rectify that information. Now, influenced by Europe, some of the jurisdictions, most notably Quebec, have added other data subject rights. For instance, the right to de-index or to stop transmitting information. What this is an individual can ask an organization to de-index any links that link to personal information that the individual may have contributed or that may have been collected on that individual. There's always an obligation, the right to lodge a complaint if one isn't happy with the way that one's personal information is being processed. In Quebec, there's also what we call a mobility right, and that means that I can ask that my information be transferred to me or to another organization. So for example, I'm consulting a doctor at a certain clinic, my doctor retires, I'm given another doctor with whom I don't really click. I then decide I'm going to go to another doctor at another clinic. I can ask Clinic A, the original clinic, to transfer my file to Clinic B, and they have the obligation to do that. So that's what we mean by data mobility. Now, also what we need to be aware of is that in certain jurisdictions, for instance, Europe, individuals are granted more rights. For example, they can oppose processing of the information, and they can also oppose any automatic decision-making process that uses personal information. So it's good to be aware of those. Those have not come to Canada yet, and they have not come to Quebec right now. So that's pretty much what I wanted to go over with respect to our legal obligations, generally speaking. Then in our practice, what's really important is we have these business transaction exceptions. These are important to understand because there is a little bit of confusion around them, not the least, well, one of the reasons being that federally, this was an exception that has been allowed for a while, and it has not necessarily been allowed in Quebec, and it will be as of the fall. So we're in a bit of a transitional period here. And what this means is, remember I was saying that we cannot process an individual's personal information without that individual's consent, unless it falls, the processing, for example, falls into an exception. And the federal legislation, now Quebec legislation, have allowed business transactions to become one of those exceptions. So what that means is I do not necessarily have to go and get an individual's consent to disclose information within the scope of the transaction, provided two sets of activities have been concluded. One before the information was transmitted, and another one after the information is transmitted. So before the information is transmitted, I have to have entered into, if I want to communicate information to another party, I have to have entered into an agreement. This agreement has to state that the information is absolutely necessary in order to proceed with the transaction, and that if we decide to proceed with the transaction, this information is also necessary in order to complete the transaction. That's the first part of this requirement. The second part of this requirement is that the receiving party has to, well, the disclosing, the receipt party, both parties have to use and disclose the information only for the purposes related to the transaction. So it can't be an at-large disclosure. It really has to be limited. So we have to scope the disclosure of the information. We have to agree that we're going to protect the information, or the party receiving the information has to agree to protect it with the same level of security as it would be protected under the person disclosing it. So the recipient has to offer the same level of protection as the disclosing party. And if the transaction does not go through, the parties have to agree to either return the information they've exchanged or destroy it. So that's prior to entering into the agreement. Usually this can be taken care of in an NDA, but it really is important when we're negotiating the NDAs to make sure that personal information has been looked after specifically in these NDAs, and it's not just covered sort of broadly, because we don't want to fall into a trap where we didn't disclose, we didn't describe it specifically enough. Frequently also, it's a good idea to include language in employment contracts, and also increasingly in privacy notices, saying that personal information may be shared within the scope of a business transaction. That's the first part of this requirement. The second part of this requirement is, once the transaction is completed, we can still use it without the consent of the individual, provided that the parties have agreed to use and disclose it only for the purposes for which the personal information was collected. So for instance, I cannot take information that I've acquired within the scope of a particular transaction and use it for a completely different purpose. So if I've collected information, for example, for shipping purposes, I've got somebody's address, their home address and their name, because I wanted to know where to ship their order. If I sell my business and that information goes with it, the person receiving that information cannot take it and say, well, now I'm going to run analytics to see where the bulk of my business lies. If the individual has not consented to an analytics use of that information, it cannot then be used and repurposed. So this is what this particular covenant is about. We want to make sure that the information's use is not going to be changed without the individual having consented to it. Again, the parties have to agree to protect the information with safeguards that are appropriate to the sensitivity of the information. And they want to give, that the parties need to give effect to any requests to withdraw consent on the part of the individual. So if the individual decides that they're going to now not, or they would like to withdraw their consent to the use of information, the parties obviously have to undertake to honor that. Again, the personal information has to be necessary for the carrying out of the business activity that was the object of the transaction. And one of the parties then has to notify the individuals that the information has been communicated within the scope of the business transaction. So this is where we stand legally. We have general obligations with respect to information collection, and then we also have obligations that are really specific to the scope the scope of the transaction and the communication of personal information within that transaction. So how does this work concretely on paper when we're negotiating? Well, one thing I like to do is I like to use the definitions to to reflect the subtleties of each transaction. The reason I like to do this is because the reps and warranties basically, and we'll go through them, we're either repping or not repping certain things. And so it's much easier in my mind, and the definitions lend themselves to greater flexibility. So I prefer to work with the definitions and then rep what I have to rep or not afterwards. And this is why I want to go through the definitions. So the next two slides are really the definitions. I have 4 definitions that I want to focus on. The first, obviously, is personal information. Now, the definition that I've provided here is the definition that reflects the federal legislation, but that is pretty similar across the board. Yes, there are variations on this, but what we want to capture is that personal information means any information about an identifiable individual. Quebec will talk about in its legislation about information that can indirectly or directly identify an individual. The European Union, though, will talk about identifiable individuals. One thing to note is that people who are deceased, personal information does not typically cover information relating to somebody who is deceased. So it really has to be an alive, living, breathing individual. The other thing to remember is that personal information is vast. So something like my utility bill could be considered personal information because it can identify me. It identifies my consumption patterns, how I consume water, how I consume electricity, how I consume natural gas. Obviously, things like IP addresses, MAC addresses, these are considered, there's a lot of jurisprudence out there confirming that this information is considered personal information. Obviously, name, address, also personal information. One thing to note is that Canada, unlike the European Union, still protects information that, even though you have made it public, is not per se considered by law to be personal information. The reason I bring this up is to cover things, for instance, like posting on an internet site, if you're on social media. If you have posted something on social media, even if you've made it public, it can still be considered personal information. The other thing, so personal information has a very, very, very broad definition. The next concept that I want to look at is process. Now, I prefer to use the word process in an agreement rather than to list a whole suite of activities In Canada, process means to collect information, to use information, personal information, and to disclose personal information. The GDPR has a much broader definition of what the word, or much more lengthy definition of what process means. But if you sort of slot it into different categories, it basically covers collection, use, and disclosure of personal information. So the next one that I'd like to talk about, the next definition, is transactional personal information. And this is very similar, and it's not that different, if at all, from definitions that we see with respect to the disclosure of any kind of confidential information. Basically, what we're doing is we're saying that transactional personal information is personal information that is disclosed or conveyed to one party or its representative, the recipient, by or on behalf of another party, a disclosing party, as a result of or in connection with the transaction contemplated by this agreement, and includes all such personal information disclosed to the recipient prior to the execution of this agreement. That's not particularly extraordinary for anybody who works with confidential information, intellectual property. It's the same kind of definition. Where things get interesting, though, is here, and this is a definition that I want to talk about a little bit, and that is data security and privacy requirements. What I prefer to do is to lump all of the requirements into this particular definition, and then rep that the target or the company is compliant with its data security and privacy requirements. So if you look at the definition includes 5 things, or can include 5 things, but there are 5 things that I like to see in it. The first is all legal requirements. So these are the requirements that are imposed by law, be it the federal legislation, PIPEDA, Alberta, BC PIPAs, or Quebec Act respecting protection of information in the private sector. HIPAA, you name it, a GDPR, all of those can fit into that category A. So these are really the requirements that the law imposes upon a company. The second category of data security and privacy requirements are the contracts that the company or the target has entered into. So what are the commitments concerning personal information that the target has agreed to honor? That is the second group of data security and privacy requirements. Then we have a third category, which is what are the obligations that the company has imposed upon itself in the form of policies? What is it posted? What have we seen in the due diligence rooms? What are the policies or procedures in place the company has said that it will abide by? So, and is it abiding by those? So that is the third category of data security and privacy requirements. There's a fourth category that we see frequently, and it doesn't only have to be this, but a good example is D, the payment card industry data security standards. So any standards that a company is held to because it either conducts a certain kind of activity or business, or that it's operating in a certain field. So those are the PCI DSS requirements. And then the fifth requirement that I like to see is the anti-spam laws, because if we're getting pushback on an anti-spam rep, you can sort of slide it nicely in here and make CASL compliance or anti-spam law compliance a data security and privacy requirement. It isn't necessarily, because it's like a Venn diagram. There's some requirements that data security or personal information protection and anti-spam laws share, but there's also a whole other category of requirements under anti-spam laws. So if you can fit them in here, you can kill 2 birds with 1 stone. Otherwise, it's a good idea to have a separate set of anti-spam reps. All right, so what does this look like when we get to our representations? Well, the first one, this is what I was talking about earlier when I was talking about the importance of defining data security and privacy requirements. If you define those, it makes it really easy to say, okay, so the company has complied and has documented such compliance with its data security and privacy requirements pertaining to the business. So that little a just covers that whole slew of obligations that the company had, and then we included in the definition of data security and privacy requirements. Then these other two are not necessarily required by law, but certainly, other two being little b and little c, but they're certainly nice to have, and it shows that the company is really in charge of its data and knows what it's doing. So the first one reps that we have the processes and procedures that are in place that are going to enable us to honor our data security and privacy requirements. And what little c reps is that we have implemented, or the company, pardon me, has implemented appropriate data privacy and security training programs. Now, I know that this may seem superfluous and not very important, but in the area, in my area, in the area of data protection, it is important because increasingly commissioners are going to look at what the company has done in order to sensitize its workforce to data protection requirements. This, anybody in Quebec can remember what happened with the Desjardins security breach, where millions of files were compromised. Well, one of the conclusions of the commissioner's report, both in Quebec and federally, was that the company had done a good job with security training, but it needed to do more. And this really puts an incentive on companies to train employees with respect to the importance of protecting the personal information that they process. So it's not just in there as a nice to have, it really is important. It's something also that can be put into place post-closing. I mean, a lot of companies are not aware of it, but it's good to bring it to their attention. Then we go into basically the company's history, how they've been performing with respect to data protection. So little d reps that there have been no orders or proceedings alleging non-compliance with data security and privacy requirements, and that the company is not aware of any such potential orders or proceedings. Then little e, we go on to breaches. So we want to rep again that the company has not suffered, discovered, or been notified of any unauthorized accesses to its security systems or to its personal information, because one thing to remember, and one thing that we frequently, or that it's very easy to forget, is that unlike an IT security incident per se, a data protection incident can also involve paper files, the loss of a file containing highly sensitive personal information. It doesn't necessarily have to be in electronic form to constitute an incident. So this is an incident in and of personal information protection incidents are in and of themselves a special category of incident, because they're not just confined to a digital platform. So what we want to do in this rep little e is basically say that we haven't been subject, or to our knowledge, we have not been subject to any form of incident, and that we have not had to notify either the commission, so regulatory authorities, or individuals involved. If there have been reps, obviously we disclose it. Pardon me. If there have been breaches, obviously we disclose this in our disclosure schedules. And then our final two reps, little f, you don't always see it. It's nice to have it because it's additional. It's an additional reassurance that we haven't made any claims against our cyber insurance. Now, not every company has cyber insurance. It's great if it does, and that if you can rep this, but not all of them do, and so this is not necessarily relevant in every case. And then we have the last one, which is a nice transition into our covenants. We want to represent that the processing of personal information in connection with the transaction, the execution and delivery and the performance of the agreement, and the consummation of the transaction does not violate any data security and privacy requirements. So those are the representations that we typically see or would like to negotiate. Obviously, depending on the deal, depending on what we discover in the due diligence rooms, it could be different. But this is a best or a good case scenario. Now I'd like to turn to the covenants. And so the covenants, again, and I apologize because I may not have presented these as clearly as they should be, but I would say A, B, C, and D deal with what I was talking about, the part 1 of the business transaction exception. And then I sort of lumped all of part 2 into little e. But regardless, these are what we expect to see. There is also some discussion as to whether we necessarily need these covenants in every type of agreement. I would say that they may be less necessary, for example, in a share purchase agreement. Certainly the second part is less necessary. The first part, obviously, we need. And then in an asset agreement or an asset purchase agreement, this covenant is really important to have for the purposes of the federal legislation and also as of September also for the Quebec legislation. So this covenant, what we want to do, first of all, is the parties acknowledge that the disclosure of the information is necessary for the purposes of determining if the parties will proceed with the transaction. And if they decide to proceed, whether the information, if they decide to proceed, is absolutely necessary for the completion of the transaction. So that's the first thing that we covenant. The second thing is, obviously, the parties agree to protect the information with measures that are appropriate to the sensitivity of the information, of the personal information. The next covenant is that if the transaction is not completed, the parties agree to return or destroy the information that was exchanged. And then we have little d, and I like little d because it makes things easier on the party who is receiving the information and then continuing the business, but it is not mandatory for PIPEDA or Quebec law purposes. But here we're saying each disclosing party covenants and agrees to, upon request, use reasonable efforts to advise the recipient party of all documented purposes for which the transferred information was initially collected from or in respect of the individual to which such transferred information relates, and all individual documented purposes where the disclosing party has notified the individuals of such additional purposes and where required by law, obtain the consents of such individual to such use or disclosure. A lot of language to say that if I'm disclosing information as a seller to the purchaser, it would be courteous for me to explain or to disclose to the purchaser why this information was collected, so as to enable the purchaser to continue using that information for the purposes for which it was collected. Remember, I was talking about repurposing a person's address for analytics purposes. Well, if the purchaser does not know that an individual has not consented to running analytics on their information, they may just decide to go off and do that. And then that puts them in violation of their original undertaking. So it's nice to have this particular covenant that the disclosing party will not only disclose the information, but also disclose why the information was collected and how it's being used, because that enables me as a purchaser to go on and continue using that information appropriately. So that's part A of the business transaction requirement. And then we go on to the second part, part B. So this is after the transaction has been concluded and we want to continue using the information. So we covenant that the recipient will only process the transferred information for the purposes for which it was initially collected, that we will protect it with the appropriate security measures, that we will give effect to any withdrawal of consent, and fourth, where required by law, notify individuals to whom the transferred information relates that the transaction was, that the contemplated transaction was in fact completed. That is usually a seller's responsibility, and the seller should look after communicating that information in the event that it is required to be communicated. So that covers the first part of this presentation. The second part will be much shorter, I promise. But that covers privacy. Now, I don't know if there are any questions. This is Zoom, so does anybody, if there are questions, I would invite you to put them either in the, or to write them in the Q&A or I guess chat. I don't see any, but if there are, I invite you to raise the questions and I'd be happy to answer them. Alternate, you can also phone me or email me and I'd be more than happy to help out. So let's move to the second part of this, as soon as I can close this box. All right, let's go to the second part, which is anti-spam. This is sometimes overlooked, and this is really, in a Canadian transaction, something that is Canada specific. In 2014, Canada, after I think it was 4 years or even more than 4 years of back and forth on this particular piece of legislation, decided to pass anti-spam legislation. Now, it's not particularly, let me see, innovative. Our American counterparts have what we call CAN-SPAM, but what makes Canadian legislation different from the American legislation is that it is an opt-in regime. So it covers essentially the same activities as are covered by the American legislation, but in contrast to the American legislation, what it is saying is that in order to receive spam, an individual has to, or pardon me, commercial electronic mail, an individual has to consent. So it's opt-in. I have actively opted, I've checked a box to receive your marketing materials. In the United States, it's the opposite. I can send you marketing materials unless you check the box saying you don't want to receive it anymore. So it's very different on that level, which makes it a much higher threshold in Canada. The other thing that I've learned recently is that in the US, the regulators are not as aggressive with respect to enforcement of their CAN-SPAM legislation as perhaps as are Canadian regulators. We are on it, and we do absolutely follow this this compliance. So it's very important that companies be aware of it. It is not legislation that is enforced by the Office of the Privacy Commissioner or the Commission à l'accès à l'information. What it is legislation that's enforced by the CRTC. And there are penalties and enforcement mechanisms that have right now much sharper teeth than the federal privacy legislation has. So what is this anti-spam? What's it asking us to do? Well, legally speaking, what we're doing is we're regulating the sending of commercial electronic messages. So that means SMSs, it means email, it means, digital marketing. Anytime you send any form of communication encouraging participation in commercial activity, that can be considered commercial electronic messaging, and it will fall under spam. And it can be as simple as, for instance, a new professional joins an accounting firm, and the accounting firm sends out a blitz saying, "We are pleased to introduce Mr. Smith, who has joined us." Unless the accounting firm has received consents to receive that kind of information, any information that is sent, that any email that is sent like that could be considered commercial electronic messaging, even if it's just saying, we are pleased to welcome. The fact that is sent by a professional body that I guess typically charges for its services as a service provider. And also if there's a link to the organization in question, that could be considered enough to qualify the announcement of somebody's joining as commercial electronic messaging. Now, all right, so I've decided that I want to send commercial electronic messaging. What do I have to have? I have to have, well, there are three things that I have to have in place. The first is consent. I've discussed this. We have to have consent in order to send commercial electronic mail. That consent can be express or implied. Implied, however, very limited categories of what can be considered implied consent. Implied consent can exist if there's a pre-existing business relationship. And what a pre-existing business relationship is a relationship between two parties that is no older than 24 months. So there's a 24-month period for which a consent is valid. If I'm sending information out because of a recall of a product, that can also be implied consent. There also can be implied consent in a situation where, for example, I meet somebody at a conference and I say, are you interested in receiving any information on privacy or our data protection practice? And the person says, yes, here's my card, please send it to me. If that is a borderline case, the best thing to do in that instance is to follow that particular interaction up with a formal request for consent. But that is an example of an area where there could be a bit of gray and a bit of maneuverability. But all things considered, the best thing to do and the best way to be clean in this area is to get express consent. Now, if I have express consent and I can send this CEM, what I have to do is I have to comply with certain disclosure obligations. So I have to clearly identify the sender. I have to provide contact information that is valid for, I think it's 60 days. And I also have to provide an unsubscribe mechanism, so an unsubscribe button. If the individual receiving my information or my messaging does not want to receive it anymore, they have to be allowed to unsubscribe. That unsubscribe button has to work, and I then have to be documenting. So this brings us to my fourth point. Again, the importance of registers. I have to keep a consent register, both of the consents that I've received when I received them, because I have to be able to track them to make sure that they're still valid. And I also have to be able to track the names of people who have decided that they no longer want to receive my messaging. And again, this is a register that can be audited, so it's very important to have it and to keep it up to date. Penalties. What are the penalties in Canada for non-compliance with CASL? Well, they're steep. They can be up to $10 million for a legal entity or $1 million for a natural person. There is also the potential of directors and officers liability, which is very frightening and doesn't exist, as I understand, in the United States with CAN-SPAM. But if you're a director or an officer in an organization and you have either overseen or worse consented to the sending of commercial electronic messaging that is non-compliant with these requirements, you can be held personally liable. So how does this play out with respect to the reps that I want to see? All right, the first are my definitions, and I can run over these quite quickly, but anti-spam law means any legislation regulating commercial electronic messages and includes, but is not limited to. So here is the name of Canada's anti-spam legislation, called CASL usually for short. But believe it or not, it is actually called an act to promote the efficiency and adaptability of the Canadian economy by regulating certain activities that discourage reliance on electronic means of carrying out commercial activities, and to amend the Canadian Radio, Television and Telecommunications Commissions Act, the Competition Act, the Personal Information Protection and Electronic Document Act, and the Telecommunications Act. I've seen agreements come back with that, with the name of that law shortened, but that actually doesn't work. It actually is called an act and not Canada's law, lowercase l. So just be cautious of that. But it really is known as CASL. CASL is also fine to use as a definition. And then B, any legislation, pardon me, in the jurisdictions where the company or any of its subsidiaries conducts their respective businesses. So as I was saying, the United States has its law regulating commercial electronic messaging. European jurisdictions do as well, which is why we put in that, that second little B. Then we have the definition of CEM, which is commercial electronic message. So that's a message, the content or hyperlink or the contact details of which could reasonably be interpreted as encouraging the participation in commercial activity. Hence my example earlier of a professional services firm that just simply announces the arrival of a new member. That could be and has been in jurisprudence considered to be a commercial electronic message. So we have to be really careful to make sure that we do have the consents necessary in order to send this. What do I look for in a representation with respect to CASL? This is, I think, a very good one. It's a very succinct one. So except as disclosed in the disclosure letter, the company has over the last look back period complied with CASL. And sometimes we can put this, I mean, if the parties agree, this materiality threshold. But what we want to see is that we have also, we've complied with CASL, and as I've said before, we've maintained the records to prove that we've complied with CASL, that we have the proper consent forms. We also want to establish that appropriate policies and procedures are in place. This is important because of the director and officer liability. There is a due diligence defense that is available to a director or an officer of a company that has been found to be in breach of CASL legislation. But they have, and the company also, if the company can prove that it really had a policy in place, trained its employees, has the proper documentation and registers in place, they can invoke due diligence. They've done their they did everything within their means to prevent the sending of a commercial electronic message, and something happened and it got sent. If you can do that, the chances of being fined are much lower, and the fines will also be much lower. And then the third thing I'd like to see is that the company has contracts with all third parties that on the company's behalf send commercial electronic message, collect electronic addresses, or install computer programs on the computer systems of other third parties. And such contracts require the third parties to comply with CASL. So my obligation to comply with this is not just me, but if I ask somebody, a service, for instance, to send messaging on my behalf, I have to make sure that they're also compliant, and they have to do the same. They have to make sure that if I've provided them a list of people to whom I want commercial electronic messaging sent, they also have to do their diligence and make sure that I have the proper consents, etc., to send this these mails, these messages. So that is it. It closes my presentation, and I'm available to take more specific comments that relate to your transactions. Please do not hesitate to contact me. I'm again in the Montreal office, and I'm here to help out. So thank you very much.